See you in court. That's something as a doctor you never want to hear. Being a doctor means that you have to deal with complaints about the treatment that a patient has received. Most of the time, the problem can be sorted out with an apology, an explanation of what happened, and a robust plan of action to put it right. But what happens when this doesn't work? Keep watching and I'll tell you. The medical profession is tightly regulated by the General Medical Council, and we must make the safety and well-being of our patients our first concern. Healthcare is complicated and we're only human. Things don't always go to plan, and this can sometimes lead to litigation. It's a big industry. The total annual cost of NHS litigation in 2019 was £3.6 billion. The numbers are staggering and getting bigger all the time. We're going to see a lot more cases in the next few years as the impact of the pandemic and lockdowns makes itself known. It's pretty grim, really. So what happens if your treatment doesn't work and you aren't happy with the explanation that you've been given? If you want to take things further to see if you might be able to claim compensation, you'll need to consult a solicitor who specialises in medical negligence. They'll ask you what happened and advise you on whether or not it's worth pursuing. Most of the time, the solicitor will work on the basis of no win, no fee. This means that there won't be any upfront costs for you. If the litigation is successful, the solicitor's costs will be awarded as part of the settlement, and they'll take up to 25% of the compensation. The other side pays. What happens if you lose? Well, your solicitor pays all of the costs. They sometimes take out a specialist insurance policy that covers these costs. The premium for this policy is paid from your compensation if you win, but if you lose, you don't pay anything. In order to prove that the treatment that you had is negligent, your solicitor will have to show that not only has there been a breach in the duty of care that you had, but also that this breach caused you harm. Breach of duty happens if the standard of care fell short of acceptable professional standards. This is the question that has to be asked. On the balance of probability, would your treatment be supported by a responsible body of clinical opinion? This is known as the Bolam principle. Even if the treatment was seen to be reasonable, it must also be logical and based on common sense. This is called the Bolitho principle. If the solicitor thinks that there is a case to answer, they write to your doctor and the hospital where you had treatment. They ask for copies of all of the medical records. These are reviewed by an expert who gives an opinion on breach and causation. You must understand that the experts are independent and they're answerable only to the court, not to the people who instructed them. Experts are usually a consultant in the same speciality as the defendant. I do expert work in hip surgery because that's the area of my expertise. I wouldn't give an opinion on, say, a complication related to the anaesthetic. If the expert thinks that there is a case to answer, then the solicitor writes to the hospital or the doctor, setting out the particulars of claim. You are now the claimant. The other side is the defendant. The hospital litigation department does its own investigation, and if they don't think there has been a breach of duty, then the fight is on. The hospital instructs its own experts who look at all of the clinical records and statements from the people who were directly involved in your care. If these experts are of the opinion that there has been a breach of duty and causation, then the case is settled out of court and you receive compensation. If, however, the hospital's experts are of the opinion that there hasn't been a breach, then the case might have to go to court. This is when it gets really expensive and time-consuming. The judge will look at all of the evidence and the experts are cross-examined. Quite often the case is settled before the court hearing, sometimes on the day itself. Both sides agree terms and it's all over. You receive compensation for your suffering and loss. The process is the same in private practice. We have to pay for indemnity insurance that covers the costs of litigation and compensation. It's very expensive. In the NHS in England, indemnity is provided through the Clinical Negligence Scheme for trusts. This is administered by NHS Resolution. It can often take years for litigation to finish. It's a harrowing process because you have to respond to letters, attend conferences with your solicitor and barrister, and relive the trauma of the problems you've had to deal with. Don't forget though that everybody wants to do the right thing for you. I hope you found this helpful. It's only a very basic outline of medical negligence, and remember, I'm not a lawyer. If you need advice about potential litigation, then you should consult a specialist solicitor. I've put some links in the description to resources that will give you more detailed information about what to do if that you think you've had treatment that's negligent. Thanks for watching. See you all again next time.